Hello, this is Dane Ciolino, and welcome to our continued class on confidentiality. As we have moved through this course, we first talked about the regulation of lawyers in general. We talked about lawyer liability, lawyer discipline, and then in our last lecture, we focused on one of the fundamental aspects of the lawyer-client relationship, namely the duty of confidentiality. Now, of course, this duty of confidentiality is part and parcel of this general duty that lawyers have as fiduciaries. Remember, fiduciaries owe the highest level of trust and confidence to their clients. And in that capacity, they've got to be loyal. They have got to be competent. But it is something that is just defined by law as a result of this relationship. And as we talked about in the last lecture, the three pillars of this lawyer-client fiduciary relationship are competence and diligence, loyalty, which is essentially the duty to avoid conflicts of interest, and confidentiality, which we started talking about last time. The basic duty of confidentiality, the kind of basic paradigm, is the lawyer and the client sitting in the privacy of the lawyer's office and the client just opening up. And in so doing, the client should feel free to give the lawyer information such that the lawyer can competently advise the client and candidly advise the client. And of course, a lawyer is not really going to be in a position to give good advice if he or she has incomplete information. So the policy that underlies this law on confidentiality really is about facilitating the representation of the client by assuring that the lawyer has complete information from a client who should not be reluctant to disclose, because the client should be comfortable knowing that the law prohibits the disclosure of anything the lawyer learns from him in the context of the representation. The starting point for this discussion, of course, is Rule 1.6a, which is the very broad and basic rule of confidentiality. It, of course, provides that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent or the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. Well, I can't emphasize enough just how broad this duty is. Remember, it shall not reveal information relating to the representation of a client. Extremely broad. Doesn't mean just information that is communicated in confidence, not just communications, not just non-public information. Any information, unless it's generally known, is going to be covered by Rule 1.6a. Starting from that basic premise that we're dealing with a very broad obligation, we then went on to talk about Rule 1.6c. Rule 1.6c is a relatively new addition to the rules, and this is, I liked it when it came out, as I mentioned in the last lecture. I liked it when it came out because it told lawyers that they can go out in the world and use and communicate client information in settings other than that cone of silence. What's the obligation? In protecting and actually protecting the confidentiality of client information? Well, basically reasonable care. Rule 1.6c provides that a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to information relating to the representation of a client. So the good news about this is just reasonable care, because that's required, not uber care, to prevent the inadvertent or unauthorized disclosure, or unauthorized access to client confidential information. So this is the rule that says, for example, that lawyers can use Dropbox, that lawyers can use cell phones and email, as long as they undertake, basic digital hygiene and they use strong passwords and otherwise exercise reasonable care. Then we spent a good bit of time in the last lecture talking about all of the exceptions to this obligation of confidentiality. Rule 1.6b, of course, contains all of these exceptions, and it's a long list. One that we spent, again, a good bit of time talking about, and I'm not going to rehash here. But I will say again that this rule is an important one for purposes of the multi-state professional responsibility exam. Lots of testable material here that just simple black letter rules that you need to understand. So by not going over them again, I don't want to attempt to diminish their importance, because they are quite important rules. But it's just important to understand that you need to focus on them and know them cold come time for the MPRE. So where does that bring us today? What I've just talked about was essentially a very brief review about where we have been. Where are we going with the remainder of this lecture? Well, first of all, we're going to talk about use of confidential information by a lawyer. Before, we were talking about a lawyer's obligation to refrain from disclosing. Now, when can the lawyer take client confidential information and affirmatively use that information, perhaps to even help the lawyer himself? That's what we'll talk about here. Rule 1.8b has a rule that directly addresses the issue. And it says that a lawyer shall not, and again, remember here we're focusing on the use of information, use information relating to the representation of a client to the disadvantage, and again, this only applies to a disadvantageous use, unless the client gives informed consent, except as otherwise permitted by the rules. Okay, simple rule. The lawyer can't use client information to the disadvantage of the client unless the client says it's okay. Well, I've always thought that the best way to explain this principle is with a hypothetical. And oddly enough, the hypothetical I've been using for years is the same one that our casebook authors have chosen to use as well. What is it? Well, it's this. You, a lawyer, are representing a company that is thinking about building a new plant. So it's out in the community looking at, your client is out in the community looking at possible sites for this new plant. And of course, you know this, and you know that developers are acquiring parcels of land in a suburb to build this shopping mall. One parcel of land remains to be sold. Your client has just decided not to buy any land. The value of that property, since it's near your client's plant, is probably going to go up because of its proximity. Now the question is, can you essentially trade on that inside information? Now, we're not talking about insider trading. This is not a security. This is information about how property value is going to increase because you know from confidential client information that this new plant is going to go in there. So you'd like to buy the parcel of land. Why? Well, so you can flip it once your client's project becomes public and the land values go up. And the question is, are you permitted to do so under Rule 1.8b? And the short answer is, yeah, probably, as long as it doesn't hurt your client. In this hypothetical, buying that property would not harm your client. It would not be disadvantageous to your client. So the rules, namely Rule 1.8b, would not prohibit you from buying that property and making a profit. Now, having said that, everything I've just said is true as a matter of ethics law, as a matter of whether you would be subject to discipline. But as we've said many times, the law governing lawyers is not just the law set forth in disciplinary codes, but also general principles of agency law, because lawyers, recall, are not just any sort of they're agents for their principals, their clients. Now, under the agency law of some jurisdiction, and this is not an agency law course, but I'm just alerting you to this, under the agency law of some jurisdictions, an agent who trades on inside information like this might be forced to disgorge the profit to the client. Is sometimes said to hold that profit in constructive trust for the principal. So the point of this problem in Rule 1.82 is B, is that you won't be subject to discipline for doing this, but whether you might have to disgorge the profits is another question entirely. Just one to think about. Okay, well, now that we've talked about the basic ethical obligation of confidentiality, let's move on and talk about two other topics, the lawyer-client privilege and the work product doctrine, or the work product immunity, whatever you'd like to call it. These are very important, and these are just other ways of coming at the same problem to further the same policy, which is we want to protect the confidentiality of client information. We're going to do it as a matter of ethics, and here you'll see we're going to do it as a matter of the law of evidence and the law of procedure. As we've talked about several times, the lawyer-client relationship is governed by a number of different bodies of law. Constitutional law, particularly with regard to the representation of clients in criminal matters. Agency law, we just discussed an agency law issue with whether a lawyer might have to disgorge profits if the lawyer were to trade on inside information. Tort law, we've talked about malpractice law already in this series of lectures. Now we're going to turn to procedural law, the law of evidence and the law of civil procedure, and see what it says about the relationship between lawyer and client in general, and in particular, regulating confidential communications. We've already talked about how 1.6, 1.9, 1.18 are all rules that govern confidential communications. Now we're going to talk about the law of evidence, more particularly with the lawyer-client privilege, attorney-client privilege, same thing. We'll talk about the law of procedure, and more particularly, we'll talk about the work product doctrine, or it's sometimes known as the work product immunity. And then finally, we've already talked about the law of agency with regard to the use of client confidential information. And as we launch off into this discussion, be ever mindful about the different scope and coverage of these standards and how they come or work together to protect confidential information in general. The attorney-client privilege, I love a Venn diagram, and this Venn diagram shows the attorney-client privilege. Now, what is covered by the attorney-client privilege? More on that in just a few minutes. But the work product doctrine also, there's some overlap, as you'll see, and I'll just tell you what the overlap is. If the lawyer prepares a memorandum of a confidential communication with a client, the substance of that communication would be protected by the attorney-client privilege, and the memorandum prepared by the lawyer memorializing the communication would be covered by the work product doctrine. That's why we have on this chart this area right here where there's overlap between the two standards, where both would protect the information. So now my question to you, and the answer which I will get from no one since this is a video, is how would we draw on this chart the Rule 1.6 obligation of confidentiality? Well, here is how you do it. That obligation is very broad, as I've said over and over and over again. Given the breadth of that obligation, you need to understand that it covers information that's not privileged. It's broader than that. It covers information that's not work product. But all information protected by the work product doctrine and all information protected by the attorney-client privilege would fit into the broad category of information relating to the representation of the client. So that's why I think this Venn diagram is so important. I think it's a very important diagram for you to understand how these principles of confidentiality work together toward that one goal of protecting attorney-client information. All right, well, now having done that, we are now going to discuss the attorney-client privilege. Well, where in the federal rules of evidence are the rules of privilege? Well, spoiler alert, they're really not in there. Rule 501 is kind of the placeholder for privilege rules. It's entitled Privileges in General, but Congress kind of punted here. It was so controversial. To this day, I don't understand what's so controversial about privileges, but privileges are believed to be controversial. And because of the controversial nature of privilege, Congress didn't get very far with them. This is all they've said about privileges. The common law, as interpreted by United States courts in light of reason and experience, governs a claim of privilege unless any of the following provides otherwise. Constitution, federal statute, rules. So in cases governed by federal law, federal criminal cases, federal civil cases arising under federal statutes, we're just going to look at the general common law of privilege to determine whether a communication is privileged. Okay, simple enough. But in a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rule of decision. So, makes sense. If the court's sitting as an Erie court, then you would like to allow state law to control. Why? Because we don't want whether a privilege is applicable to be part of a forum selection decision. So yeah, for those reasons, under 501, in a civil case, state law governs privilege regarding a claim or defense for which state law provides the rule of decision. So this is a long way of saying that Rule 501 punts, at least with regard, it punts to federal common law for federal claims in federal cases, and in civil cases, Erie cases, it punts to state law. So where does that leave us? Well, it leaves us talking about a lot of state law eventually, but let's first look at waiver. Now, this is a relatively new provision. I really almost would like to do this after I talk about the basic law of privilege, the attorney-client privilege, but it follows sequentially after 501, which we just looked at. But what is it? Well, this applies to disclosure of communication or information covered by the attorney-client privilege or the work product protection. Now, of course, work product is a rule of procedure that protects the work done by a lawyer. And the attorney-client privilege, we generally, again, look to federal common law or state law for what that privilege is. More on that in just a second. But suppose that a disclosure of a communication protected by one of these privileges applies. Then what do we do? Well, that's what our discussion is about now. Okay. Disclosure made in a federal proceeding or to a federal officer. When a disclosure is made in a federal proceeding or to a federal office or agency and waives the attorney-client privilege or work product protection, the waiver extends to an undisclosed communication or information in federal or state proceeding only if the waiver is intentional, only if the disclosed and undisclosed communications or information concern the same subject matter, and they ought, in fairness, to be considered together. This is designed to forgive people for making unintentional disclosures of privileged information. It happens. There are times when if you're doing a big document production, you inadvertently produce some memos between lawyers and clients. This is all about giving you some relief from that. So, you know, only if the waiver is intentional and the information concerns the same subject matter and it needs to be considered together are we going to allow it. Now, as to inadvertent disclosures, this is kind of the converse of what we've just looked at. When made in a federal proceeding or to a federal office or agency, the disclosure does not operate as a waiver in a federal or state proceeding if the disclosure is inadvertent, if the holder of the privilege or protection took reasonable steps to prevent disclosure, and the holder promptly took reasonable steps to rectify the error, including various steps set forth in the Federal Rules of Civil Procedure. This is essentially known as the clawback provision. If you've inadvertently disclosed, but you weren't just sloppy in your disclosures, you took reasonable measures, but we all make mistakes and you made one. If you inadvertently disclose after taking reasonable steps to protect disclosure, and then after you realize you made a mistake, you go back and you follow the clawback provisions of the Federal Rules of Civil Procedure, well, then you're allowed to claw them back. Now, a lot of this is beyond the scope of what we're doing here in this evidence course, but you just need to understand that Rule 502 exists and that this is a limitation on waiver of attorney-client privilege in federal proceedings or if the disclosure is made to a federal office or agency. The attorney-client privilege. Now, this is the biggest and most important of all the privileges that you would consider. And what is it? Well, except as otherwise. Now, notice what I'm using right here for our source, our standard, professional conduct standard, our evidentiary standard is the restatement. And this is the restatement of law governing lawyers made by the ALI, of course. It's not in the rules of evidence. Why? Because remember, Congress punted in the rules of evidence as to privileges. But under Restatement Section 68, except as otherwise provided, the attorney-client privilege may be invoked with respect to what? Well, communications. So from the very beginning, understand, the attorney-client privilege is only about something that you say from your mouth to another person or they say to you. It's not about things you see, generally. It's about things you say and hear. All right. With respect to a communication made between privileged persons, like lawyers and clients and lawyers, more on that in just a second, in confidence for the purpose of obtaining or providing legal services. So this is the most important single slide on the attorney-client privilege. You just have to know cold that the privilege applies to communications made between privileged persons in confidence for the purpose of obtaining or providing legal assistance to a client. All right, now having said that, let's think about or focus on each one of these requirements, starting with a communication. What is a communication is fairly obvious. Under Section 69, a communication within the meaning of Section 68 is any expression through which a privileged person, as defined in Section 70, stand by, undertakes to convey information to another privileged person and any document or other record revealing such an expression. So if you are this could be a nonverbal communication, but if you are trying to tell another privileged person, your lawyer, what you did wrong, you're conveying information. And also any document, if you do it in an email or a memorandum or other record revealing such expression, that's a communication. Simple enough. Between privileged persons. Who is a privileged person? Well, obviously the client is a privileged person. The client's lawyer is obviously a privileged person. And then this is where it gets more interesting. The classic attorney-client privileges has one lawyer talking to one client. They're obviously privileged persons, but also agents who facilitate communications between them, like interpreters. Maybe if your client is a kid and the mother is in there, or maybe an accountant is in there to help work through the numbers. So agents of either who facilitate the communications and agents of the lawyer who facilitate the representation, agents of the lawyer. So this could be the lawyer's paralegal, the lawyer's investigator, the lawyer's secretary, the lawyer's law clerk. They're all agents of the lawyer who facilitate the representation. Just because they're in the room doesn't mean that the privilege is busted because of the lack of privileged persons being present. In confidence. This communication has got to be in confidence. And when is a communication in confidence? Well, if the communication is done under the circumstances where the communicating person reasonably believes that no one will learn the contents of the communication except other privileged people. Now, obviously, if you're in the lawyer's office and you're talking about your case, a reasonable person would believe that no one else is going to hear. But if you're talking to your lawyer on an elevator at One Shell Square, and you turn to him in a crowded elevator and say, "Hey, lawyer, I got something to tell you. I killed my spouse." Well, that is not going to be privileged. Why? Because it was a communication. It was between privileged persons. However, the person who made the statement, namely the client, should not have reasonably believed that no one else is going to hear the communication. It was not done in confidence. Now, there are issues that presented in jailhouse communications. When you talk to someone on a recorded telephone line, those aren't in confidence because you know that prison guards may be listening. So be very careful. Don't assume that when you're talking to your client on a prison telephone system that that's, quote, in confidence. In fact, presume quite the contrary. Okay, that's the basics of the lawyer-client privilege. Let's talk about the common interest privilege, because this is important in real life. Under this section, if two or more clients have a common interest in a matter, but they're represented by different lawyers, if they agree that they're going to work together and they're going to exchange information concerning the matter, a communication of and they're talking about otherwise privileged matters, not the weather, then it's going to be privileged. Those communications are going to be privileged as against third persons. That's the key here, as against third persons. Any such client may invoke the privilege unless it has been waived by the client who made the communication. So, for example, suppose you and I are both being charged with bank robbery, and we kind of are working together to work up our defense. Well, as between us and the government, us and the world, what we talk about is privileged. However, if we get in a fight between ourselves, the privilege is not going to be considered any good anymore, because any client may invoke the privilege unless it's been waived by the client who made the communication. So again, as to the outside world, it's still good. And if the person who makes the communication wants to waive it, then it can be waived. So you just got to be careful with common interest privileges. They exist as long as everyone's unified, they work, but once you've got dissension and breaking in the ranks, it gets murkier. Unless clients have agreed otherwise, a communication is not privileged as between clients. That's what I was just saying, in a subsequent adverse proceeding between them. That shows you just how fragile this privilege is. If you start a fight, then the privilege doesn't exist as between the two who previously had a common interest. Next issue, organizational clients. You as a lawyer will represent not just flesh and blood human beings, but also corporations, partnerships, LLCs. What are the rules with regard to privilege and corporations or other organizational clients? Well, Restatement Section 73 provides that when a client is an organization, and again, broadly defined, doesn't matter whether it's a corporation or a partnership, the attorney-client privilege extends to a communication that is otherwise privileged under all of the principles that we have just discussed, is between an agent of the organization, like an employee, an officer, a director, and a privileged person, like a lawyer. It concerns a legal matter of interest to the organization and is disclosed only to privileged persons, as defined in Section 20, and other agents of the organization who reasonably need to know of the communication in order to act for the organization. So if you're representing an organization and you sit and you have a discussion about, in preparation for a deposition, you talk to an officer and you all talk freely back and forth about the nature of the deposition and the information, that's going to be privileged. Why? Because it concerns a legal matter of interest to the organization, and it's kept within privileged persons and those agents of the organization who need to know in order to act for the organization. So I don't want to overly complicate this. This rule is pretty straightforward. The basic principle to take away is that the attorney-client privilege protects communications with organizational representatives and then extends to the organization itself, not just to flesh and blood clients. Now let's talk about exceptions. And the most important exception to the attorney-client privilege, the lawyer-client privilege, is the crime-fraud exception. So suppose I come to you and I say, hey, you know, I really want to defraud the investors in my company. Can you help me draft up the documents? And then we go on and we talk about this aspect of the offering or whatever the deal is. Can that communication be discoverable? Well, the short answer is yes. Why? Because the attorney-client privilege does not apply to a communication occurring when a client consults with a lawyer for the purpose, later accomplished, of obtaining assistance to engage in a crime or fraud, or aiding a third party to engage in a crime or fraud, or regardless of the client's purpose at the time of consultation, uses the lawyer's advice or other services to engage in or assist a crime or fraud. So understand, the lawyer doesn't even have to know at the time she's giving the advice that she's helping the client commit a crime or a fraud. If the client takes that information from a well-meaning lawyer and later or gets the information for the purpose of perpetrating a crime or a fraud, or even if at the time everyone's innocent, but the client later uses those services to assist in a fraud, then the attorney-client privilege doesn't apply. That means a subpoena can be served on the lawyer or the client, and either could be forced to disclose whatever it is that they discussed in the context of that advice. Okay, so let's wrap up with some critical principles. And the reason I've included this is because on the MPRE it's important to understand kind of at a high level what we're talking about. And also for when you're just a lawyer. All right, first of all, the attorney-client privilege protects communications, not facts. So, for example, if I tell you where I've buried some treasure, well, that's a communication. You cannot then go disclose that, even if somebody gives you a subpoena. That is something that's protected by the privilege. However, just because we've talked about that buried treasure doesn't mean that it now, if somebody finds it, is somehow protected. No, it only protects communications, not the factual information contained in those communications. And if that factual information comes out otherwise, well, then it's going the attorney-client privilege won't have a role in someone's ability to use it. It protects verbal communications, not physical appearances or physical evidence. If I bring to you a gun and we discuss that I used it to kill my wife in the past, and now I want some legal advice, that communication is going to be privileged. That verbal communication, if we did it in email or we did it orally, that's going to be protected, but not the gun, for example. That doesn't become privileged just because we talked about it and I brought it to you. It still may be, if, for example, the lawyer gets a subpoena, subject to the subpoena. The attorney-client privilege belongs to the client, not to the lawyer. The lawyer has a duty to invoke the privilege. If the lawyer is asked a question about what did you tell the client, what did the client tell you, the lawyer has an obligation to invoke the privilege and say, I can't disclose that because it's privileged. Now, having said that, since the client holds the privilege, if the client wants the lawyer to reveal it, the client can say, lawyer, you answer the question. And the lawyer must answer the question. The lawyer can't say, this privilege is owned by me too. It's not. It's the client's privilege. The lawyer has an obligation to invoke it, but if the client wants to waive the privilege, the lawyer has to respect that. Also, the attorney-client privilege may be waived by intentional or inadvertent disclosure. There are relatively new rules in the rules of evidence that we've already discussed that talk about waiver and try to limit the scope of waiver, but just understand that you got to be careful. If something's privileged, you got to take some efforts. I mean, Rule 1.6c says we have to undertake reasonable efforts, and the same is here, to prevent inadvertent disclosure. Because if there's inadvertent disclosure under the law of many jurisdictions, that waives the privilege. And then finally, this attorney-client privilege, of course, exists while the client's alive, but it even continues beyond the client's death. So just because the client's dead doesn't mean that you can start blabbing or responding to subpoenas. You still have to assert the privilege. Last topic of the lecture, the work product doctrine. What does this cover? And where is the source of this? What is the source of it? Well, the source, of course, is in civil procedure. And here I've just put up Federal Rule of Civil Procedure 26b3, which is the source of in the federal rules of civil procedure for this doctrine. But of course, it just exists in the general law of lawyering. What does Rule 26b3 say? It says that a party may obtain discovery of documents and tangible things prepared in anticipation of litigation or for trial by or for another party, or by or for that other party's representative, only upon a showing that the party seeking the discovery has a substantial need of the materials in the preparation of the party's case, and that the party can't get it without undue hardship. Well, that's the basic rule, but for our purposes and for the purposes of the MPRE, it's a little simpler just to look at the Restatement of Law Governing Lawyers provisions on this. And what do they say? Restatement Section 87 starts out with some definitional provisions. And it's always a little goofy when you start out defining things, and then after you have your definitions, then you go to the doctrine, but that's the way that this is laid out, so here it is. First of all, what is work product? It's material prepared by a lawyer for litigation in progress or that's reasonably anticipated. So, for example, if you are a lawyer for a company and you heard that a company truck has gotten in an accident, and you go out to the scene and you interview the driver, you interview witnesses who are nearby, and you make notes of those. Well, there's no litigation yet. The accident just happened. But since it's anticipated, the materials you prepare, like your notes, for example, your transcriptions of interviews, pictures you take, those sorts of things, are work product. Work product then comes in two varieties. First of all, opinion work product, which is the most protected type of work product, which includes the lawyer's opinions or mental impressions. So if you, for example, say, ooh, it's dark out here right now, or that pothole was very deep, whatever, those are your mental impressions. Those are protected more. An ordinary work product is everything else. For example, if you get a witness to write out a statement there, or the witness tells you something and you just write what she says. Again, it's prepared by you in anticipation of litigation, but that is ordinary work product. So what's the rule? Well, here it is in Section 87. Work product is immune from discovery or other compelled disclosure, which means if you get a discovery request, you don't have to disclose it. If you get a subpoena, you don't have to disclose it. Unless, if it's ordinary work product, and this is typically if you take statements from witnesses. That's the classic ordinary work product. Or pictures, ordinary work product. If ordinary work product, an exception applies, or the inquiring party has a substantial need for the material and can obtain it without undue hardship, and if opinion work product, an exception applies, or extraordinary circumstances justify disclosure. So the general rule is you can't be forced to compel the disclosure of work product unless if it's the less protected kind of ordinary work product, if some other exception applies, or there's a substantial need for the material and the other party can't get it without hardship. And if it's opinion work product, again, more protected, you have to disclose it if an exception applies or if extraordinary circumstances justify disclosure. Again, a bit of a higher bar to overcome. All right, well, that's all I want to say about confidentiality. We, of course, started out our lecture in the last lecture by talking about the basic principle of confidentiality and the exceptions and the ethical obligation. Then in this lecture, we talked a little bit about the use, the ethical prohibitions on the use of confidential information, and then moved on to the rules of evidence and the rules of procedure and talked about how those bodies of law, that doctrine has additional safeguards to protect and to further that, protect confidential information and to further that underlying goal of encouraging free disclosure, a free flow of information between lawyer and client in order to facilitate the lawyer's representation.